Okay, ladies and gentlemen, a very good afternoon to each and every one of the REHDA members who have signed in. Today, we are actually have invited a number of very eminent panelists who will be able to assist us and to help us understand the COVID Act as much as possible. Now, we all know that the COVID-19 pandemic and also the unprecedented imposition of the MCO itself, as well as its variations by the government so far, has inevitably brought around a lot of damages to businesses in almost all the sectors of the construction industry and also the property development industry. Now, finally, the Act has actually come into force on the 23rd of October, and the COVID Act actually modifies the provisions of about 16 prevailing statutes and contractual obligations. So including even the Housing Development Control and Licensing Act 1966. The COVID-19 Act, amongst others, seeks to provide an interim reprieve from legal actions that is faced by industry players, especially in the construction industry due to the pandemic itself. Now, however, as the Act was only gazetted 6 months later after the call, in fact, there was a very long wait for the Act to actually come into force. Some view that the Act has actually come too little and too late. And at the current review, many have found a lot of loopholes. And to what extent this is true. And we also find that the Act actually has quite a number of open-ended clauses which need further action. Now, in this three-part webinar sessions organized by REHDA Malaysia, we have a panel of experts in the various fields, in legal, in construction, as well as also in the finance sectors, who will discuss various pertinent issues concerning the Act. Now, on our panel, we have Dato Engineer Soam, Heng Choon. He is currently our president of the Real Estate and Housing Developers Association. And he will also be one of the prime movers who was helping out to enact the COVID-19 Act and contribute towards some of the measures. And Dato Nitin Nadkarni is a senior partner of Lee Hishamuddin, Allen and Gladhill, and he's currently the head of the International Arbitration and the Tax, Sales and Service Tax and Custom Practice. He has many years of experience, and I think we are very fortunate to be able to have the opportunity to listen to some of his opinions and views and also recommendations for the improvement of the COVID-19 Act if it goes for amendments. Next, we also have Dato Jeffry, Mohd Ali, who is currently the head of Consumer Finance and Community Financial Services of Maybank, Malaysia. And as the head of Consumer Finance, Dato Jeffry plays a very critical role in ensuring that the bank is able to provide financial and lending accessibilities to the consumers. And especially in this critical time when cash flow and financial issues are in the forefront, we would like to hear from his views and also his recommendations. Next, we also have Dato Ezumi Harzani, who is currently the president of Pertubuhan Architect Malaysia, PAM. And he is also one of the forefront in advocating some of the issues and also addressing some of the issues faced by industry players in the COVID-19 Act itself. Now, without further ado, I would like to invite Dato Nitin to present to us his views and also his opinions and probably some recommendations on the COVID-19 Act that is in force. Dato Nitin, over to you.
Okay, thank you very much, Dato, for the kind invitation, and thank you very much to everybody who has taken the time to come and join us today. Can everyone see my screen?
Yeah, you can see.
All right, I have to do something here to it because it's a bit strange. Okay, There we go. All right. So my talk is on the dealing with the COVID Act in respect only of the professional services aspect. And there are three parts. I'll give a short overview of the Act. Then the second part will address what is a professional service, and the third part will address practical resolutions. Okay. Well, let's have a look at what are the related legislation first. COVID Act relates to the Prevention and Control of Infectious Diseases Act, the PCIDA order, and the PCIDA regulations. These are the specific legislative provisions that trigger the COVID Act and the provisions of the COVID Act. Now, if you look at the Act, the long title, it is to provide temporary measures to reduce the impact. So they don't make any bold promises that they're solving the impact. They're only going to try and mitigate the problems of this. Now, this is a brief timeline. As you all know, we all remember 18th of March, the implementation of the MCO, and then you had various dates in between with the RMCO and the CMCO. And only after all of that was over, in August, Dewan Rakyat passed the COVID bill. The Act itself only came into force in October, 7 months after the whole emergency began. And there are consequences for this delay that you will see as we go through. Now, it modifies, as Dato Charlie said, a lot of pieces of legislation, and I've listed 16 pieces of legislation that have been modified by the Act. Some of them are relevant to construction professionals, some of them less so. But you will notice that it only, in respect of Sabah and Sarawak, it only affects the limitations ordinance. It has no impact on local regulations that were made, particularly in Sabah, where there were certain health regulations passed by the Sarawak state government, I'm sorry. So now let's look at the Act itself. What does it say? It says that the ability of any party to perform the keywords, the inability of any party to perform any contractual obligations, and I stress the word obligations, arising from any of the category of contracts specified in the schedule due to the measures prescribed under the PCIDA to control and prevent the spread of COVID-19 shall not give rise to the other party exercising his or her rights under the contract. And examples of the kinds of categories of contracts of importance to our listeners here is construction work contracts, construction consultancy contracts, contracts related to the supply of construction materials, equipment, or workers, performance bonds, professional services contracts, and leases or tenancies of non-residential immovable properties. Now, taking first professional services, it's not defined in the Act. A nice term is used, but there's no definition in the Act. It's not defined in the COVID Act. It's not defined in the Contracts Act. The closest you can come to it is in the income tax deduction for promotion or export of professional services rules. And it includes legal, accounting, architectural, engineering, medical. Is it the same? Is that the meaning? Or can professional services include the person who prepares your claims for SIPA, for example? What is a professional in this context? Quantity surveyors surely would fall within the context. Interior designers, there's a whole load of people, but we have no definition and no benchmark for what is a professional service. The schedule that I read out, of course, can be amended by the minister from time to time, and he has not done that. Now, here is where we come into the problems. It relates to contractual obligations. It relates to an inability, if you remember the word, and it is due to measures prescribed or taken under the PCIDA. So let's take, first of all, the question of, let me just see just a moment, please. Let's look first at the question of contractual obligation. And that's quite important. The Act only affects obligations. It has no impact on rights. And why is this important? To give you an example, the PAM 2018, contractor may apply for additional loss and expense. This is a right. It's not an obligation. Section 7 wouldn't be applicable. Now, in a lot of contracts, you have rights to claim for certain things, and you have to give notices at specific times in accordance with the contract provisions in order to make those claims. We all know that quite often emails in these contracts are not enough. You must send it by registered post, or you must deliver by hand in order to bring yourself within these provisions. How do you do that when the MCO is in force? And Section 7 doesn't extend the time for the exercise of rights. The second thing, the source of the obligation can only be the contract. It only suspends contractual obligations. So it has no impact on obligations created by law, by statute, health safety regulations, health safety ordinances. It has no impact on tortious obligations. So I may have a contractual right to look after a site, but I also have a duty of care under tort. The contractual right may be extended. The tortious right is not affected at all. And if I can't do my thing because of the MCO, I can still be sued under normal statutory law, health safety ordinances. I could still be sued at tort. So there's a gap. It only affects the contract. Inability. What is an inability? It doesn't explain. Are you unable if it just becomes more expensive? Is it something that there's an inability to perform if it takes longer? In usual, ordinary English, the mere fact that you need to spend more money to perform your obligations, or it takes you a little bit longer, does not amount to an inability. An inability usually means I can't do it at all. I can't do it at all. It's like a complete prohibition. But it doesn't seem to cover where you are merely impaired in your ability. So these are all questions that are going to arise in disputes and arbitrations and in court cases in due course. And because the Act doesn't define these things, you will get different decisions. Because all these contracts have arbitration clauses, different arbitrators will treat them differently and come to different conclusions. So there's an imprecision. This is the third big problem. It is only due to measures prescribed or taken under PCIDA. So first of all, it must be caused by or contributed to by PCIDA, not by anything else. And secondly, it can't apply to policies which are not mandated. So we all remember that there was an MCO, and then there were second periods where there were relaxed procedures. An employer who said, I look after my staff, and I'm going to do more to look after my staff and allow them to work from home. I'm going to do more than is required under PCIDA, will not be able to take advantage of this. And even more importantly, our construction industry depends on supply chains from outside of Malaysia. We import our materials. A lot of our contracts are by Chinese contractors who may have workers in China. They were not able to enter the country. Before the MCO, if you remember, China put a block on the eve of Chinese New Year. That was January. Our MCO only came into effect in March. What happens in respect of contracts where for 2 months nothing could come out? And I actually have a real life case like this, where there was a factory which had a downtime. They needed some machinery, which had to come from, of all places, Wuhan, because that's an industrial center, and they couldn't bring the machinery in. And so the factory was shut down for 2 months. And then that means that they're in breach of their contracts to supply, but the Act has no application to that because it only applies to issues arising under PCIDA. If I can't import steel because of things outside the country, that's neither here nor there. If I can't send letters because airlines are not flying, because letters are done, I can't answer. That's got nothing to do with PCIDA. So there are huge gaps in this Act. Now, then the other thing to note about it is there's no requirement to apply or give notice for Section 7 to apply. If the elements are met, then the inability immediately gives rise to the rights, stops the other party exercising his rights under the contract. So that's insofar as Section 7 is concerned. Now, what are the alternatives to this? There's force majeure. There's no provision for force majeure in the COVID Act. If you remember, Dato Charlie talked about how it was too little too late, and the minister gave a response in which he said, oh, no, it's not too little too late. It's because we wanted to be perfect. We wanted to take everybody's views into account and cover every possible situation. I'm not sure why they didn't put in a force majeure clause, which would have solved a lot of problems. So you only have force majeure if the contract provides for it. And in my firm, we've done an article you can find on our website, which we've gone through all the standard forms, whether it be PAM, IEM, CIDB, FIDEC, and all that, talking about what the force majeure, what they are and aren't. Now, the other thing is force majeure, if it applies, it suspends the whole contract. Section 7 only suspends performance of that obligation directly affected by PCI-DA regulations and nothing else. So it may suspend only part of the contract. Then there is another alternative, which may be frustration, where something becomes impossible. But the problem with frustration is it brings the whole contract to an end, and not many people want the contract to come to an end in these difficult times. So it's an independent right. Then we have a saving provision, COVID Act, and there are problems with the wording of this as well. It says, notwithstanding Section 7, any contract terminated in that period from 18th March shall be deemed to have been validly terminated, forfeited, received, commenced, granted, or carried out. Now, as a lawyer, if I read that literally, it means that even if the contract was wrongfully terminated, even if you didn't have the COVID Act, I might say the contract was wrongfully terminated because you didn't have a right to terminate. I didn't breach the contract. But this Act says any contract that is terminated is deemed to be validly terminated. It's deemed to have been commenced, which it shouldn't have said. What it should have said is the way you assess it, it shall be assessed as if this Act had not come into force. But it doesn't say that. It appears on the face of it to make the termination valid or forfeit, or validly forfeited or terminated. Any bond that has been called on has been validly called on. Does that mean the court can't re-examine and say that, or an arbitrator can't say that it was not validly called on? Any arbitration commenced, supposing there were jurisdictional issues, it shall be deemed to have been validly commenced. It's a piece of very sloppy drafting, and it's made worse because there are other provisions in the Act, saving provisions elsewhere in the Act, and we don't have time right now to go into them, which are very well drafted and which show exactly how it should be drafted. They didn't even have to look at other legislation. Now, what have they done in terms of dispute resolution? I think everybody knows that in Singapore, the legislation that was passed, they had a panel of assessors to provide, to resolve any disputes arising, whether or not it had been affected, to provide quick resolution so that everybody knows in life. What have we got? We've got any dispute may be settled by way of mediation. You can't force people to go to mediation. So any disputes that arise will then have to be resolved in the usual dispute resolution process, whether it's arbitration or adjudication or court processes or whatever. They're not very helpful to us, unfortunately. Okay, so here are the other things that have happened. This is the Limitations Act that, that we all know, 6 years from the date a cause of action accrues. And that has been amended so that any limitation period that expired from 18th March to 31st August is extended to 31st December. But if your limitation period expired on 1st of September 2020, then it expires on 1st of September 2020. There's no extension of time for it. Okay, so practical resolutions. What can I suggest? Aside from amending the Act, is that given the lack of case law, this is going to be litigated up and down the country, and there's a degree of uncertainty in the interpretation of the Act. You've just got to be prudent to try and comply as far as possible with contractual obligations. Discuss with counterparties, maintain good records at all times. I mean, all of you know, everybody in this industry knows about the decision of the federal court in Eureka. For how many years everybody thought that the Adjudication Act was retrospective? The federal court made a decision in Eureka and Bauer cases saying that because an act can only be retrospective if the act expressly says it is retrospective. So now you have to ask yourself, does this act apply to contracts that were signed before the act came into being? If you take the Eureka and Bauer decisions, the federal court said, no, you can't affect contracts that came into being before the act came into force. This is an uncertainty. Sure, somebody is going to take this up to the federal court. I think the federal court will have good sense, but imagine the state of uncertainty when all it would have taken is a piece of legislation saying this act shall apply to contracts before as well as after the act came into force. Okay, well, And I think with that, I was told to keep it very brief, and I've therefore tried to keep things very brief. Thank you very much for your patience in listening to this. Okay, now I have to figure out how to stop the share. There we are. Thank you all.
Dr. Charlie, you are muted.
Hello, can you hear me?
Yes.
Yep.
Okay, very much thank you to Datuk Nitin for your very elaborate exhortations on the various issues that has arisen as a result of the COVID-19 Act that was implemented. And unfortunately, he has not resolved quite a number of our, what you call contractual, as well as also legal issues that has arisen.
In fact, Dato, what I can say to you is that if Parliament and the drafter wanted to give a COVID present gift, a Christmas gift to lawyers, they did it by creating the act in this fashion, because we lawyers are going to make a lot of money out of the legislature, and so are the arbitrators and adjudicators, which I don't think was the intention of passing this act.
Yes. Yes, thank you so much. And I think we have now the various other panels which we would like to open up for their views. And especially, let's start with Datuk Soam. Can you share your views on the impact of COVID-19 on the real estate, as well as also the construction industries that are employed by the real estate industry? Over to you, Datuk Soam.
Yeah, thank you, Dr. Charlie. And thank you to the fellow panelists for joining us today. And we have a number of people out there who already know the impact of the COVID-19. I mean, it's already coming to the 9th month of the pandemic. And of course, in Malaysia, when the MCO was implemented, I think REHDA, on a proactive manner, engaged with the various authorities. And as early as April, we already told the government that they must come up with a COVID bill and make certain necessary arrangement as to what Datuk Nitin has mentioned, whether we should declare it a force majeure event. But they felt that it's not necessary, and then it dragged on. And when Singapore came out with the COVID bill in the month of April, it was all done in a week. In Malaysia, the draft has been floating everywhere. And explained just now by Dato' Nitin, because of the saving clause, whatever action that has been taken is considered being valid. So everyone will be jumping into the bandwagon to take action against the other party. And I believe that I heard that there's some of the aggrieved parties are now complaining that this came a bit too late. I think we make comments, REHDA make comments in the earlier days that this act should have been earlier, but no point crying over spilled milk. And the issue here today is that we, through BIPC, did have various meetings, and we agreed that at the BIPC level, to be headed by PAM, maybe to not so much as a mediation, more a discussion group within the aggrieved parties, especially on the contracting side, on the construction aspect of it. And coming back to our industry, we have two different aspects of it. One is our contract, third-party contract, our contract between us and the buyer. And we have another contract between us and our suppliers and our contractors. And the problem with the Act, the COVID-19 Act, is that it doesn't address the issues in the whole supply chain. And in the earlier days, when we were in discussion with the ministries as to what should come out in the Act, it has all been changed. Whatever we discussed, most of it were not adopted, and the final shape is that maybe they want to, like Dato' Nitin said, they want to make lawyer rich by coming up with this act. But we now have to see what we need to do. And the end of the act is 31st of December. Okay, we have only another 21 days to do what we can do. And in Singapore, they have amended the act twice since it was enacted in April. We have not done anything, and I believe there are certain things that we want it to be amended or can be done better. And my view is that because this pandemic has caused serious implication and impact on the whole supply chain, okay, And for us here is like we are dealing with buyers. So there are a lot of obligations of the buyer that cannot be fulfilled. Similarly, the obligation from the developer side also cannot be fulfilled because of the MCO that was implemented from 18th of March up to, I would say, the end of the CMCO, which is actually 9th of June. Only from 9th of June onwards, there will be a bit more activities. And to us is that we hope that, we thought that this COVID bill will help us to address a major part of the issue. I wouldn't say that it didn't help, it has helped, but not the full 100% that we would have liked. So we would say that it have maybe helped us in 50 or 70% of what we wanted to address. So the balance 40% are still not there yet. And to fellow developers and stakeholders, I think we work in ministry to our best of our ability to come up with certain guidelines on what should be done for both the developers and also the buyers. And I think that we will address in a separate session later on. So today, coming back to the professional services, I think in the BIPC, which is our members include the people from the various professions, the architects, the engineers, the planners, and also the QSs. So they are all there in this presidential council, and we said that there are a lot of things that we need to use our common sense to address whatever dispute, conflicts that we have. And I agree with Dato Nitin to say that in Malaysia, there is no compulsion that the aggrieved parties can actually, must go through mediation. We can choose not to go through mediation. And it's something not very right from day one we mentioned. And we were advocating maybe a special court or a tribunal or whatever, and everybody has to go through it, like what Singapore did. And I gathered until today, Dato Nitin, correct me if I'm wrong, I don't think we still have that group of mediator out there, or maybe they're choosing the mediator now.
They have asked people to volunteer, and so I know this because I'm on the panel, but they're still in the process of compiling the panel.
Yep. So that, having said that, I think we need to actually expedite those things. And for the contracting parties, because of the impact, I felt like this is more like a starting point where I want to say that everybody has to use their common sense in trying to address issue that they have, knowing that the industry has been badly affected and is due to no fault of any of the parties, not the buyer, not the developer, not the contractors, or not the supplier. So we need to use our common sense to address the issue that we have. And I think we can see clearly that our businesses have been affected, especially developers' business, from the the Q2 result of most developers because of the MCO. Is something that we have not encountered before. There was complete stoppage of work on site. Like Dato Nitin said, there are a lot of supply of material that was impossible because they are imported and our borders were not open, and there were no flight as well. So they're definitely bound to be disruption. And I think that normality came back only after the 9th of June when we have the CMCO imposed. Things were better. And in the third quarter, we can see that things are normalizing, I would say, maybe up to 70, 75% or 80%. But then with the reimposing of the CMCO, things got the other way. And then now with, cluster coming out from construction side, I think definitely work will be disrupted and will be impacted. So that's my view for now, Dato Charlie.
Thank you, Dato Soam. And also, we would like to now invite the professional services lead consultant, usually is the architect. And I would like to invite Dato Ezumi. Basically, you notice that construction services or construction consulting contracts is covered under the schedule, which listed out the categories of contracts which is affected and can be addressed by COVID-19. So, Dato Ezumi, do you have any views and also on how you are affected, basically as an architect and the rest of the consultant that is involved in the construction industry? All right. Okay. Dato Ezumi, over to you.
Okay. Thank you, Dato Charlie. Okay, good afternoon. Good afternoon, everyone. On the professional services, architecture services, practices, maybe Dato Charlie just mentioned to me just now, I need to update a little bit what happened on the ground with regard to the architecture services. We did a survey through the board of architects. I think it was in June, if I'm not mistaken, earlier. So I do not have the latest data, but we have some interesting data based on the previous survey that we did. Based on the number from the respondent that we have, yes, we have to admit that many of the practicing architects out there are affected by this MCO and also the pandemic. From the survey, we got the information that about 11 number of practices actually now has ceased operation. This is the worst case scenario where actually they have to stop, they have to close shop and do other things before they come back to architecture, hoping that later the business climate is going to be better, and then they will come back to practice. So some have gone to the university doing teaching part-time. Even at university also now, they do not have physical classes. So it's really a hard time to some of the practices. But not all are in that situation. Some are still surviving, and there are many measures that have been taken by the professional architects to survive under this situation. From the survey also that we got the feedback that about 276 number of practices basically reduce the overhead expenses, mostly to mitigate the situation, whether they keep the smaller number of staff or smaller size of office, and of course about 267 actually reduce the salary, the staff salary, allowance, and other perks, and many of them also retrench the staff. About 111 retrench the staff, and about almost 30% actually managed to get financing from the bank to sustain their operation, and mostly are small practices, so who actually get the assistance from the financial institution to survive under this situation. And of course, the bigger impact is that out of the number of practices that I mentioned just now, about 450 of that practice, half of it actually says that they are badly affected in terms of human resources. So it means that they have to retrench or lay off or give them VSS to their staff. So most of the practices, about more than 90% actually has reduced or shrink in terms of number of staff and size. So this is the scenario. So on the professional practices, especially on the architecture practices on the ground. But of course, despite of all that, we are still the party as the contract administrator. We have the responsibility. I think what Datuk Nitin mentioned, also Datuk Soam mentioned just now, that architect as under PAM contract 2006 and also PAM contract 2018. We as the contract administrator, we have a very important role and also duties under this situation. So we need to facilitate the parties in achieving mutual objective, other than allowing them to go to litigation or fighting in court. So for that reason, I think PAM has also established at the moment a group of mediators. So we have close to 50 mediators at the moment. So PAM would like to announce that we will provide a mediation service to any of the disputing parties, or even to the architects, to our members, the architect himself, if they need or if they require assistance from PAM to help to mediate their situation, then we can also do that to mediate the disputing parties. So of course, under PAM contract, we have clause 35 under PAM contract 2006 and also PAM 2018. We have the provision for mediation under clause 34. So PAM contract are well covered in terms of the provision for mediation, but of course for other contract which without the mediation clause, I think the COVID Act also allow the provision which actually the parties may proceed with mediation. But what I want to mention here, other than formal mediation that we can do, I would like to recommend that for architects and also consultants who help in administering the contract to encourage the mediation, not just formally, but maybe informally. You can have meeting, discussion at site office, meeting room, or even Starbucks coffee shop, as long as you can achieve mutual understanding, mutual agreement to resolve the issues amicably and just put on a piece of paper, get things done and proceed with the work. The keyword now actually is the survival of the project for the interest of everybody. So that's why I always advise that our members, the architects, and even the other consultants, we must take practical dispute avoidance approach. This is for the benefit of all the contracting parties. Okay, so that we have to take proactive roles to facilitate the disputing parties, the employers, and also the contractors, that we have to encourage them to come and sit down together to discuss. Until if there is no way you can discuss informally, then maybe you should go to a formal mediation. And of course, during this period, until end of the year, there won't be any litigation, any court action will be allowed, because the COVID Act actually temporarily suspend all these the contractual right of the parties. And I think, and generally, I would rather say that we have we have difficulty in assessing OT as well, because there are also various interpretation and views with regard to force majeure. Maybe later we can discuss about it in detail. But I know that I also receive a lot of messages, emails from our members saying that should we give the EOT under the CMCO, or we limit to MCO only. So there are a lot of views, opinions. So that's why we continuously engage our members and try to explain to our members that what we should do. Basically, we try to be fair. We have to be fair to both parties, the contracting parties, and we will try to resolve the problem amicably. So one thing that I want to remind the architects out there, regardless of the situation in our office, but we still have to play our roles to be independent and impartial in deciding whatever dispute between the parties. And of course, to the developers and also contractors, okay, we will do our best to resolve this. And before you proceed, okay, to gear up with a litigation, a court action, please come down. Okay, I mean, sit down together. We try to discuss this to find a mutual solution that benefit both parties. Don't kill the project, because you kill the project, you kill us all as well. Okay, without the project, architect has nothing to do, no job. So that's why we need to survive. We can work things together. Let's sit down and discuss this together. So I think Datuk Charlie, okay, I will hand it back to you. Okay. So thank you, Datuk Charlie. So that's all.
Okay, thank you, Dato Ezumi. We are actually coming back to Dato Jeffry. Basically, I think moratorium so far implemented has actually assisted a lot of cash flow issues between the parties. But at the same time, I think this is only a temporary measure. The issue will then have to resurface back again. But we would like to also know whether the COVID-19 itself has actually impacted very much on the financial institutions in our country, and especially the banks and the major banks who have actually contributed towards this moratorium. Can we invite Dato Jeffry to give your views and also whatever that you wish to recommend? Thank you.
Okay, thanks, Dato Charlie. First and foremost, let me probably thanks Sharida, yeah, for having us, or rather inviting Maybank to be in this esteemed webinar today. Yeah, First of all, probably if I just want to comment on the COVID Act with regard to how it's impacting the bank, I only saw, I think, under one item, Roman number 8 in regards to HP Act. I think it was mentioned by Dato Nitin earlier, whereby I think during this period, the Act says that I think for FIs, no banks, EU, under HP Act, we shouldn't be, amongst others, shouldn't be repositioning all those car, for the areas. It's just one of it, which is covered under this HP COVID Act, Dato Charlie. Now, to specific on your question, I guess, yes, whether it's impacted the financial institution in Malaysia, obviously, yes, it is, right? But probably, if I may speak in the perspective of my bank, how we manage to maintain our healthy liquidity because of probably our strong structural future, right, in terms of underwriting, prudence underwriting, as well as probably the strong capital buffer that is already able to withstand all these headwinds, losses, and so forth. So on the moratorium, yes, that is what's our part to really comply with the requirement by the government. How can we assist our borrowers, our housing loan borrowers, mortgage, hire purchase, and SMEs to really try to assist, to give that kind of relief during this hard time. And it is something that I guess is being done by most banks. Yeah, is already the first moratorium, auto moratorium, it was ended in 31st of September, but it was, as we all know, Dato Charlie, is extended now under targeted repayment assistance. So I guess this is basically something that really impacting the bank. More so if you look at the exposure, the total exposure in banking in regards to borrowings, basically mostly a lot coming from the what I call it, vulnerable sectors. You see, like oil and gas, tourism, I think construction and so forth. So it is yes, it's something that we need to have a support to our customers. By the same time, I think the bank need to safeguard internally and our own service quality. Now, in terms of probably how this pandemic, I guess the pandemic have taken a toll to everyone, right? Employers, employees, as well as all the even household income. And this is where I guess people are, I know they are very particular in so far as how they spend their money. And is something that to the bank, how can we assist the borrowers, how we can continue to assist the borrower. We basically need to look at in terms of their, their business had failed, for instance. Was mentioned by earlier that we also have a lot of our, I guess our industry being affected in terms of retrenching of employees, job retrenchment. So generally, I guess, of course, this had impacted the bank, in regards to our revenue, in regards to asset quality of the bank, and obviously also in terms of our net interest margin compression. Dato Charlie, how actually impact of this COVID-19 to the banking sectors?
Thank you, Dato Jeffry. We would like to also invite all the participants that if you have any questions, you can actually go to the Q&A, jot down your questions, and at the same time, then we will then refer to the various members of the panel. And to continue this discussion, I would like to also refer this question particularly to Dato Nitin. Now, Dato Nitin, if you were to look at the act itself, which is actually valid for 2 years, but there is actually a ending date for the operation of the act. And the operation of the act is actually after December 31st. If there is any extension for any event that occurs during this period, then the minister is actually required to extend. We are actually nearing the end of December, and we have not heard of any measures of an extension for issues that will arise before December 31st. Therefore, should there be a need for extension? Is it very necessary for the minister now to apply and get it gazetted for an extension beyond the December 31st?
The short answer, Dr. Charlie, is yes. I mean, the minister, and it must be the minister doing it, as we all now know, and he should gazette it before the 31st of December. Don't gazette it on the 1st of January, because you never know when the court will say, well, sorry, you had to do it before the 31st of December. So I think they have to get their skates on. They have to stop worrying about what happened in Ipoh this week and focus on what is happening in the country and in business generally, and give the extension of time. The Act is valid for 2 years because that is the maximum period the minister can extend it. After that, only the Prime Minister can extend.
Yeah. So, but if you look at the both section of Section 7 and Section 10, like you mentioned just now, there was actually some controversy on the expiration date. Now you notice that Section 7, it's operational upon 18th of March up to the 31st of December, whereas Section 10 is actually from the 18th of March up to the 23rd of October as the day of the Gazette itself. So there is actually a conflict of timing. So do you foresee any problem arising as a result of this, that you only have what they call the 2 months for issues to arise out of Section 10 and Section 7? There is a lapse there.
I don't think there is actually a problem, a discrepancy, because they address different things. One section, Section 10, addresses events that have occurred, actions that have actually already been taken up to the date of gazetting of the Act, because until it was gazetted, we didn't know if the Act was going to be gazetted or passed. So people would have acted based on what they thought was their best interest, and it's to uphold that. So once the Act is gazetted, you should no longer, everybody knows the Act is in force, you have to act on the basis of the Act. So the extension only has to come under Section 7, that it should be extended beyond this date, because we haven't finished with the measures that are prescribed. It's quite clear, looking at our infection rates, that there will be an extension, at least of the CMCO, into next year, which will have an impact. But as I said, what is also important is that they need to extend the scope of this beyond PCIDA. The supply chain, you've got to look at the whole supply chain, and they're not looking at the whole supply chain. Half of the Malaysian supply chain comes from abroad.
Yeah, it's true. So basically now we have actually only about 2 months on the balance from until the 31st of December, from the 23rd of October, for any action to be taken to address the issues. So do you think that it is all the more that the minister has to extend it beyond 31st of December?
Yes, absolutely. Absolutely. I fully agree with you. He does have to extend it because there are still going to be a lot of issues that are going on. There are still going to be delays. There are still concerns, and there is still an impact on the industry of the measures taken under PCIDA. He must extend it, Dato. There's no two ways about it.
Thank you so much, Dato. Okay, now we have some questions coming in. And this is from one of the participants. For the COVID-19 bill, what is the provisions that the developer has against the buyer in claims on LAD from the purchaser if the handover date is this year, but outside the MCO, but in the CMCO period? I think this question, the participant, we will refer this question when we answer it on the third session, when we deal with the Housing Development Act itself, especially how it's affected by the COVID-19 Act. All right. Now, the next question is, if the force majeure clause is exercised by the contractor, could the developer do the same to the purchasers? I believe also this question will be answered at the time when we do the third session. All right. And the third question is, if the CMCO is extended, will the COVID-19 bill be extended as well? That one, I think, Dato Nitin, probably you will be the best to answer this.
Yeah, no, they should extend it. The minister must extend it, but it doesn't necessarily mean that he will extend it. if they're going to extend the CMCO, it is vital that they take steps, and they should be putting those measures in place now. And I'm sorry to hear from you, Dato, that from what you say, there's no move that you are aware of, and you will be much closer to them than I am, that there's no move to extend it. There is a crying need for them to extend the applicability of the Act, and they need to do the Gazette notification. They need to start the measures in place now, because by you say 3 weeks, but I can tell you within about 10 days, all the civil servants will be going on leave. They'll be using up their leave for the rest of the year. And there'll be nobody there to do all the gazetting and do all the provisions. And nobody there. So I think you will somebody has to go and tuchok the minister to go and extend these provisions.
So we certainly hope that some people from the ministries or Ministry of Law will be able to receive these messages and do something about this. All right. Okay, now for the next question, I think Dato Ezumi, I would like to refer this to you and also to Dato Soam. This one is especially the issues on the claim for what you call loss and expense. Now, do we need to actually ask the contractors to apply for these claims within this period? And if they fail to do so within this period, are they actually out of time? Because they are only allowed to bring up the issue and claims during the operation period of the COVID-19 Act. So which is probably up to 31st of, 31st of December. Yeah. So Dato Ezumi?
Okay. Thank you, Dr. Charlie. I think, like I mentioned earlier, that I think we have to encourage not just the contractor, even the employer, the developer, try to focus on how the interest of the parties rather than the contractual rights. So that's why I say that sometime under this situation, especially under the MCO, to serve notice or to notify for the intention to claim the loss and expense or even EOT, maybe there will be issues. They cannot send the notice, they cannot serve the notice. So my recommendation, my suggestion is that for the assessor, the contract administrator, the architects or the QS for the assessor who want to assess the claim for expenses and for the architect to assess the EOT, maybe you can put aside this precedent requirement, okay, for the precedent condition for the application of loss and expense claim and also EOT. Otherwise, okay, it's going to be very difficult because if we have to assess and evaluate if there is a real cost to the contractor, and if the contractor is supposed to be paid, then we should assess it properly. And of course, this is where I say that this is not the usual contract. Okay, this is where you need to sit down together to get both parties to mutually agree. Well, I can say that if the loss and expenses claim during for the period during the MCO, I think in my view that is can be assessed as a force majeure. So it means that it is a natural event. Then by right, both party, the contractor and also the developer, the employer should bear their own cost. But what happened after the MCO? CMCO, for example, when actually the contractor are allowed to go to the site and resume the work, but not in full capacity. This is the difficult part. This is the difficult part where actually the architects need to assess it. Okay, because it's not that the contractor cannot go to work, but they can go to work, but in different 50% of capacity. And sometimes there's a lot of hindrances for them to go to work. They need to get the employees, the workers, and get the COVID test. There's some hindrances that is going will affect their performance, their progress as well, and also affect their expenses as well. So I would like to quote the example. I think Dato So mentioned that Singapore COVID Act, they have revised it twice.
Yes.
But there was another one, the amendment number 3. number 3 was done on 2nd November, if I'm not mistaken, last month, which is very, very interesting. The third amendment, actually, the provision, they amended, I think, the section 8 of that clause.
Yep.
It says that where actually the co-sharing of the expenses. So first, they give the fixed EOT, 4 months fixed EOT. And then on top of that, the parties are allowed to share the cost, 50-50. Of course, there's certain capping, not more than 0.2% per month, and the total of capping of not more than 1.8%. I think this is probably a model that we can study. If I may suggest for the next amendment to this act, the COVID Act, maybe we should consider something similar. This actually alleviate a lot of confusion among the stakeholder, the industry, especially the assessor, the contract administrator will need to make decision on this. So I think this is something that I think the government should look into it, how that we can facilitate the parties, the contracting parties on the ground, and also the contract administrators.
Okay, Dato Soam, do you have anything to add?
I think the question here is this way. I mean, when we're talking about construction contract and then versus the contract that we have with the buyer, one is a contract where, like Dato Ezumi say, probability of force majeure clause in there, and the one that we have with the buyer is force majeureless contract. So it's a different thing altogether. And I think in Malaysia, the way we adjudicate the contract or we administer contract sometimes is actually a lot of goodwill between the contracting parties, especially between developers and contractors. And if you are long-time contractors of the developer, you want to tend to maintain the goodwill wherever is possible. And given this difficult time, as we all know, it's not due to a fault of anyone. A lot of the contracting parties, they come to their senses to say that this cost maybe we'll share. This cost I take up, this cost you take up, you know. And this is not a time to talk about whether it's a force majeure, whether there should be loss and expense and all this. And the important thing is to sit down, discuss what is the additional time required. And I think a lot of them are referring to the other part, especially clause 32 to 38 regarding the housing development side, where the period from 18th of March to the 31st of August has been excluded from the calculation on the delivery period. So a lot of contractors thought that automatically the contract between them and the developer will have this exclusion as well. So which is not the way that I think PAM even look at it. So there must be a lot of goodwill here in administrating the contract in the coming days, so that we don't get entangled with a lot of our time being spent going to court in the future. And I think one of the aspects I think we should learn is that don't be shy to learn from our neighbors. You know, they have gone through it earlier than us. I think they have modified it, like say 2 or 3 times now, and they know some of the practical issues that is not being addressed. And it's good that we need to have a clear guidance in the act so that everyone minimum will have to follow what is in there as well. And in Malaysia, like I say, there's no compulsion that you must go through mediation. So I think once you don't agree, you bang the tables and everyone will go in their own direction, and then they will appoint their legal counsel and go after each other. That's why before we start, I ask you, any of the contractors have killed any of the developers or otherwise, you know? So I think this is my take on the thing, because we tried to ask the minister in the earlier days, that was in April when we met up, to say that, can we declare this as a force majeure event? And they keep thinking, you know, and then they went back, it took them a month, 2 months, and then they say, no, they're not. But I still remember the works minister did mention in one of his media briefing that this is a force majeure event, but it's in a media briefing, it's not in black and white, or it's not in writing as well. So it has not been declared a force majeure event, but whatever in the clauses in the contract that we have, I think it's left to everyone to use it. And that's where lawyers will pounce on it and then try to make a buck out of it. So it's important that we all look at it in a wholesome manner. And developers are caught in between, because we have a contract with the buyer and we have a contract with the contractors as well. And I mentioned that the supply chain is not just limited to suppliers. Here we have an issue, like example, defects liability period. The government has now asked us to extend the defects liability period accordingly. But the contractors will come to me and say that, sorry, I'm not going to extend the defects liability period for you. That's not in the contract. You know, so what should we do now? You know, so it's an issue. It's a money issue again. I can extend the contract, but you please pay me. Like the lift service provider, the guy who provide you the lift. You know, a 6-month additional servicing cost is quite a lot. And if they are repairs to the parts and all this, what will happen? So these are things that I think we all need to address and look at it in a wholesome manner rather than piecemeal. And I think when we highlighted this in the first instance to the government, they don't quite understand, you know, the way business is being done. So that's why we are in where we are today.
Okay, I think I would like to refer the next question to Dato Jeffry. Dato Jeffry, basically the moratorium, as we all know, has been able to help out with the various loan person who have actually taken loans. And subsequently, for the past 6 months, they have been actually been able to hold on to any repayments. But knowing the situation and economy that is actually not picking up fast enough, many of them are still sort of brought down with so much of the debts that they could not repay. What is the bank's take on this, and how does the bank intend to assist, and to which extent and how long can you actually do it?
Yeah, I think first and foremost, banks also, I guess we also need that kind of support even from the government, right? Because the government, whatever support by the government to the public, it will spur the economy, it will spur the purchase of property and so forth. So that's basically what bankers want, right? Because we need to have a disposable income of the public in order for them to probably to purchase a property or to buy their next car, right? So I think we have seen I think even in the budget 2021 announcement, the Penjana, right? The Pelanjana Semula Ekonomi Negara. I think there are a couple of incentives there. For instance, like stamp duty exemption for purchase of properties, exemption of RPJT, as well as the upliftment of the 70% loan to value, really to help improve buying interest among the consumer. So to the bank, this is really what we want now. How can basically the government come up with policies which, in a way, giving the relief burden to the consumer, but at the same time, they have the disposable income to really come forward to the bank. So to purchase property. So probably one of our wish list is say like the bank will be relying on fast disbursement of financing of consumer mortgages. So as we are facing now, they are probably the bottleneck in regards to perfection of documentation. So our wish list is, can we have these like digital signatures by the government department, for instance, like perfection of legal aid lane office. Because as we see now, we are not able to really bring those documents. I guess our solicitor are unable to bring the document. So can the government actually allow like a digital form of signature or e-signatures, in the land office? So to speed up, I must say, speed up completion of documentation, as well as speed up the disbursement of consumer borrowing. I guess that is probably the ask from the bank. The other thing is probably a policy, Dato' Charlie, something like, can we allow, say, a developer to have option of progressive payment of completed property, for instance. It says now, I think for completed property, we would expect the borrower to pay it in lump sum, right? And the bank will give a lump sum loan to pay the developer. But this, of course, have a big tool in terms of the financial capability of the purchaser, right? And hence they are able to come up with the bank borrowing. But what if, let's say, we have a progressive, maybe 50% upon S&P, and the next 50%, probably 12 months or 24 months later, after the signing of S&P, so that they're able to actually own this house, and we were able to provide that sort of financing. The other thing is something like for property under construction. No, like can we defer those even servicing of interest, because these are banks policy, but we also relying on sometimes government. So here sometimes when I refer to government, I'm referring to, of course, our BNM, right? So can we allow, say, progressive interest to be capitalized, right? While they are still probably, so it's like to really giving the kind of relief, because this borrower, they might be still renting a house, for instance. So while they are renting a house and now they need to come up with servicing of bank borrowing, I guess it'd be a big tough for them financially. So can we have something like, okay, we will defer the servicing of interest, will only be paid probably 24 months upon completion. So by doing that, they're able to continue renting the house while the house that they have purchased is still under construction. So it's a less burden to them. So those are probably the asks from as far as for me, the bank is concerned. What can really the government do to? Yeah, they have the relief to the borrower, right? There's a lot of relief to the community, like what we mentioned earlier about moratorium. Those SRF fund or special relief fund for the SMEs. But is that enough for this component of the societies to really able to come to the bank and, hey, now I want to purchase this property, can you bank finance me? Because we go to look at in terms of their financial capability and so forth.
Actually, Dato Jeffrey,
Dato.
this is actually referring to what happened in Singapore sometime in April. And the moment COVID-19 hits, the banks actually came up with proposals to each and every borrowers in the in the loan market, especially the mortgages. And they actually offered a rescheduling of loans in the package, which actually is more long-term rather than on a moratorium in the sense it will be extended and you keep on deferring the debt. You actually offer for very low payments for this period of 2 to 3 years. And subsequently, then it picks up. And at the end of the day, then it builds over the longer tenure. But we don't see our Malaysian banks moving in that direction to actually resolve the problem in a long-term basis. What is your take on this?
Yeah, this is what we call a graduated step-up repayment, Dr. Charlie. I guess, yes, point noted is something that we need to look at it. What's really is probably the core focus right now is basically our existing borrower, right? I mean, we give them the moratorium, we do extension of the loan tenor. But I guess your question is now what can we do to the new entrance into the property market. Yeah, so yeah, we have that graduated step-up repayment, which in Maybank we do have it, but it's just that it's not being properly marketed.
Okay, thank you so much, Dato Jeffrey.
Sure.
And there is a question coming in from the participants. Can the extension of delivery of vacant possession due date be challenged in court of law if KPKT approved developers to extend the due date beyond 31st of December 2020? The extension of time approval was signed by the director of JPN, but not signed by the housing minister. I think this one is, this question probably is referring to the EOT that was given under the housing controller. Perhaps we will answer this on another occasion, right? Because this one doesn't fall under these COVID-19 issues. Okay, and I have a question for Dato Nitin. Now, Dato Nitin, you notice that Singapore itself has actually gone into various stages of amendments, and they are quick enough to respond. If you were given the choice of recommending for amendments to the COVID-19 Act, which particular issues would you be focused on in order to get the government to try as far as possible to amend those items in the COVID-19 Act?
Okay, The key things, and I'm not necessarily referring to Singapore, but the key things they need to amend. Firstly is they should make it a force majeure event. Under our law, force majeure is only under contract. There's no law. So they should actually say these are force majeure events. Number two, like Singapore, they should make a provision for sharing of the risk of this pandemic. If you look at our standard form contracts, if you look at the JKR contracts and all of that, you get an extension of time, but you don't get any money. There's no sharing of risk. So the entire burden falls on the contractor. The next thing I think they should be looking at quite carefully is what is the definition of inability. You know, that they need to specify that a little bit more carefully. I think those are the three key areas that I would like them to. And fourth, you need to have a quick mechanism to decide, like Singapore has, a table of assessors who can make a quick decision on whether something actually did impair the ability to do the work. No point leaving it like this open-ended to be fought out in battles over court. The whole point of the COVID Act is to avoid having to go to arbitration, to avoid having to go to court, and to have a quick solution for all of these matters.
It's true. And the question on force majeure, if the force majeure itself is not stated inside the contract, we all know that the COVID-19 was actually to address this, what you call missing clause, particularly in construction contracts.
Yep.
Does it really fully settles the issue of force majeure by the COVID-19 Act?
Nope. The COVID-19 Act is not necessarily a force majeure provision. Yep. It is only force majeure if it is provided. Can I share screen and show you something?
Yes, yes, please.
I'll do that. If I can now bring... okay, this is from an article that two members of my firm, some members of my firm, I think Ms. Crystal Wong and another member of my firm wrote, which you can get it on my website. So we've analyzed, if you look at the various forms of contract, and you look at what is the force majeure clause. Okay, let me show you the clearest example. That's the DB, JKR form DB1, revision 1 of 2010. So this,
Nitin, I think your screen is not fully enlarged.
Is that right? Let me just see. Sorry, let me see if I can do that. Let me see what I can do on this. Sorry, let me see whether I can enlarge this entirely.
Yes, you got it. Yeah.
Okay, yeah. You got it now?
Yes.
You can see it now. Huh? So if you look at the JKR DB form, if you look at clause 28, it actually says, it actually deals with an outbreak of illness of an epidemic nature. That is a force majeure clause. Now you compare that with the JKR form. That deals with, okay, there's a general definition, but it isn't necessarily so specific. Then you look at the PAM 2006. It does not list the events. It just says any circumstances caused by governmental or regulatory action. So I think that would, where there's actually an MCO, that clearly falls within it, but not necessarily anything else. And this also says epidemics. So that's a good clause that will give you the provision. But you look at the CIDB form, it talks about war, rebellion, riot, commotion, you know, but no mention of pandemic. And then you look at the IEM form, and it actually says it includes matters of nature which an experienced contractor could not have reasonably foreseen. Now, then you come to this question, could a reasonable contractor have foreseen a pandemic in a part of the world where we had SARS and we had MERS? It's not entirely clear. Whereas if you put a statutory provision in there saying this is a force majeure clause, then there's no argument. This acts as a force majeure event. Finished. Then everybody understands. And then if you look at all of these clauses, if you go back, as I say, to the DB form, if you look at the JKR DB form, which actually talks about epidemic nature, no money. No money at all. So the government declares it's a pandemic. you get an extension of time, but the government doesn't have to pay you for all your costs during that time. So you do need express statutory provisions such as they have in Singapore to say that there should be a cost-sharing provision. And I know Dato earlier said that, yes, people should sit down, they should talk, they should do this, they should do that. But, you know, we are in the worst economic situation I have seen in 35 years of practice. I've seen the mid-80s recession. I saw the Asian financial crisis in 97, saw the 2008 global financial crisis. This is the worst because in all the previous crises, people could go to work. We can't go to work here. So there is no money in the system. And when there is no money, nobody is going to voluntarily share risks. So you have to have a statutory provision for sharing of risk. You have to have a statutory provision that requires people to share the costs of this.
Okay. Is that all?
Yes. I mean, that's what I wanted to say on this point. If there isn't an express force majeure clause, number one, if there's no force majeure clause, force majeure doesn't apply. Number two, if your force majeure clause is not worded properly, and I showed you two examples, one which talks about epidemics, very clearly covers, another which says it doesn't cover things which an experienced contractor could have foreseen. And if I am acting for a developer, I will say, well, you know, we had SARS. You remember how we shut down so many parts of the country when there was SARS? Singapore was shut down, Hong Kong, we had the bird flu, we had all of these things. You should have foreseen this. So it's very problematic, honestly.
Okay, and I just like to find out the difference that you have mentioned just now on the force majeure and frustration. And I believe that there are out there many parties who have been affected by the COVID-19, thereby causing huge loss and expense, and they would like to find the best excuse to actually abandon their contracts and sort of terminate their contracts.
Okay.
Do you foresee a lot of parties going towards more on frustration rather than force majeure?
I mean, if you have no choice, people will say frustration, but I don't know that this constitutes a frustrating event. It depends on the type of contract. If you are talking about a construction contract, which has a 3-year window or whatever, I can't see that this is sufficient, because to be frustrated, it must be impossible to perform. But if you're talking about a contract for supply of particular goods, which says that those goods have to be imported from, say, China, and have to be delivered to site by a particular date, let us say 1st of April this year, then the chap can say it's impossible, and therefore the contract is frustrated. It is going to depend on the nature of the contract, whether it is that the test for frustration is not whether it becomes more expensive, not whether it becomes more difficult, but whether it became impossible to perform. And that's quite a high threshold, unfortunately. Our law is not like the civil law countries. In the civil law countries, they have actual provisions. You know, the French law countries and even Chinese law countries, they have a lot of provisions to deal with these situations. Our law is very much, you look after yourself, I look after myself under contract. We have the British system. Everybody looks after themselves. And if the contract doesn't provide, the loss lies where it falls.
Mm-hmm. Okay, I want to refer the next question to Dato Soam. Now, Dato Soam, what happens is that there are a lot of extension of time that is actually given towards the contractors as a result of the delay in the works. And especially all those delays are actually assessed by the architects. Can it be commensurated with the delay and also the extension of time to be given by the purchasers to the developer actually working on the back-to-back basis?
I think developers have to be clear here. I say the contract we have with the purchaser doesn't have a force majeure clause. And I explained that by Dato Ezumi under the PEM form, that's the form that most developers use today. Dato Nitin is talking about JKR form of contract, design build contract, so it's a bit different. So the way that is in the form, PEM form of contract 2006 and 2018, it refers to pandemic, and the thing is that it's a force majeure event. So I think there's a question there by one of the purchaser. Can we use the same clause against the purchaser? There's no way that we can use it because our agreement with the purchaser doesn't have a force majeure clause. whereas the one with the contractor has a force majeure clause. And the issue that why I mentioned the whole supply chain is not properly thought of from the beginning when they enacted the act is that the carve out time frame from the March the 18th to 31st of August, I wouldn't want to use the word extension of time. This is a time that is being frozen, taken out from the contract between the purchaser and the developer. But it's not necessarily the same between the contractor and the developer, because why the government arrived at that is to make the administration of the contract between buyer and the developer easier. Whereas the contract between the developer and the contractor, they were allowed to go back to work, but of course not at full capacity. So there will be a lot of argument related to this. So it should have been better off to be clear in the whole chain, between the buyer and the developer, this is a time frame. Between the contractor and the developer, this is a time frame. Otherwise now, the administrator of the contract, that is the architect, is left to adjudicate what is the best time possible. I think they are now having headache, whether it should be up to 9th of June when the CMCO commence, the RMCO commence from then till end of the year, or what. And then suddenly from RMCO, we went back into CMCO again, So, but activity is at 100%. So there's still a lot of contention between the parties concerned here. And I think we then told the government in the earlier part, that was in April, May, when we were going through, we look at frustration, I agree with Dato Nitin, it's impossible to exercise frustration because it's not impossible to do. We are still, over a construction contract of 2 years or 3 years, maybe 3 months you are not able to work. Otherwise you can work, and thing is quite difficult here. And to me, what is given to the purchaser need not necessarily be given to the contractor in this aspect. As to sharing of costs and all this, I think that is the biggest question that every developer and contractor is looking at today. Given that now also because of the requirement for mandatory testing, and it could be a periodic testing, so the cost can be quite substantial. So who to bear the cost? I think, as I say again, like Dato Nitin didn't quite agree with me to say that come to census and all this. But at the end of the day, a lot of the contractors have been working for developers for a long period of time. So they don't mind, I take up this step this time, you maybe reimburse me a bit here and there, and then get on with life. But there are also people, even without this COVID-19 already, they're up in arms with each other. So for those contracts, they will go at each other, irrespective of what there is.
Okay, next question I want to refer to Dato Ezumi. Dato, actually, when we talk about loss and expense claims, now if the extension of time is given based on force majeure, or put it this way, even for COVID-19 measures that is actually put into place, and architect will then certify an extension of time. Now, in this case, normally because it's a neutral event and both parties are actually not to be held responsible for it, can now the contractor claim for loss and expense for the COVID test that is actually imposed on all the contractors, as well as also the sanitization in the event of any infection? What is your take on this, Dato Ezumi?
Okay, thank you, Dato Charlie. I think I would rather look at MCO specifically during the MCO, but not CMCO. So that will be clearer to be aligned with the provision of the PEM contract. Under PEM contract, contract 2016, 2018, and also 2006, there is a AOT clause, clause 23.8. 23.8, where actually one of the relevant event is force majeure, and the force majeure under the definition actually specifically mentioned force majeure means any circumstances beyond the control of the contractor caused by terrorist act, governmental or regulatory action, epidemics, and natural disaster. Similarly, what shown by Dato Nitin just now. So I would like to see that the first period of MCO, where actually nobody are allowed to continue with working or continue non-essential services as a strict order that there's no movement, movement that allowed at that time. So I'd like to see this period as a force majeure. The reason why there is a clear order by the government. I look at this in two situations. Pandemic or epidemic is another provision which is also defined as force majeure under PAM contract. But before the virus or before the pandemic or epidemic arrive at the site or at your workplace, so that force majeure for that reason has yet to happen. Okay, because at that time when it was detected not all over the place, maybe it was detected in a few states, but not all over the country. But the government regulation at that time imposed the MCO saying that nobody can move. That actually a strong reason for us to look at that as a force measure due to governmental or regulatory action. So either way, both due to epidemics or governmental and regulatory action are falls under the definition of force measure under the PAM contract. So for that reason, okay, if EOT was granted, and I believe EOT have to be granted for this reason because there is no movement at all, then if the application submitted by the contractor under this provision, under this relevant event, then contractually there will be no loss and expense will be paid to the contractor. So, and we have to remember during this stage of MCO, there were no requirement for contractor to do the COVID test because they are not allowed to work at all. Until later, during the CMCO, then only they are allowed to work provided they get the approval from MITI or Ministry of Health. Then they have to do certain tests, including the COVID test. So that's why I say that during the CMCO, then the contract administrator, the architects, need to assess it differently. So it is not strict force measure anymore because they are allowed to continue with to work. Then now it depends on the EOT, whether the contractor now want to claim for the EOT or not during that period, because they are allowed to work, but not in full capacity. So if the contractor still claim for EOT, then the contractor may be entitled to claim for the loss and expense, depending on under which provision of the contract that they are claiming for the EOT. So basically, the loss and expense claim or for the COVID testing or whatever requirement, compliance requirement, it depends on the EOT. Okay, if we look at strictly on the contractual angle. Okay, so I just give you an example. Okay, in some of the projects, although that the contractor already got the green light to go to the site. Okay, the MITI may give the during the CMCO, the first part of CMCO, MITI may give the permission for contractor to go to site. But at the same time, the architects or the engineer were not allowed to go to site. So the architect may issue instructions say that you are not allowed to proceed with the work because we are not there to supervise. So that actually put a hindrance for the contractor, but there's some cost because the contractor probably has done the COVID test or whatever. If you look at strictly on the contractual angle, now, okay, the contractor is entitled EOT because the AI issued by the architect. And for this reason, AI issued by the architect, the contractor is entitled to claim for the loss and expense, for the expenses, idling. But this is where actually the situation, if you look at although that AI was issued by the architect, there are other events that actually causes architect not to issue the AI because the architect were not given the approval to go to the site at that time. So that's why I say after the MCO, during the CMCO, we have to look at on the actual impact to the contractor's progress of work, the actual event, what preventing, because there are many other issues. Sometimes some of the issues, they cannot get workers at that time because some of the workers actually some went back overseas, or some they cannot get the permit. So there are many other issues. So that's why I say that in my views, COVID test is part of the operational cost that appears, okay, due to this pandemic, but it was not, it was unforeseen during the tendering stage. So when I say that it was unforeseen during the tendering stage, it was unforeseen by both parties, neither the developer, the employer, nor the contractor. So this is where actually we need to take the middle ground, okay? Because it's not that any of the party tried to cheat either party, but at that time nobody foreseen this is coming to the ground. So the best way is that before I say that yes, the contractor can claim or not, we have to look at the overall, okay, what are the reason and how this actually can help both parties, the developer and also the
Because
contractor.
Dato, this is actually on the two stage, at
Yeah.
that during the time when the work is to commence, you
Yeah.
have to do a COVID test before the work can commence. But
Yes.
while the work is in operation and there is an infection, thus causing another, what you call, testing and finally, of course, sanitization. So there are two levels of loss and expense here. Which one is claimable and which one is not claimable? So in your course of evaluation, do you have any, what you call, experience in dealing with this matter?
In my views, okay, the first part is quite clear, quite straightforward. Okay, to enable the contractor to proceed with the work, then contractor need to comply with certain provision or requirement of the SOP. This is where I would suggest that for the contractor to resume the work, it's going to be give the benefit to both parties. This is where actually the cost sharing can be applied. So the cost can be shared fairly, okay, by the contractors and also by the developer. But on the second scenario, where actually due to the infection during the work, and then the contractor has to be responsible for this, because the contractor, unless if the contractor has already take all measures, follow the SOP, but it still happen, then it is beyond the contractor control, then probably the party need to sit down together again. But if it is the negligence of the contractor not complying with the SOP, I think the contractor has to be solely responsible for that.
Because this is actually presenting a lot of dilemma to a lot of consultants dealing with the claims. All right. Okay. I think as a, what you call, since time is actually do not permit, we would like to go around to all the panel and also to ask this relevant question on your recommendations that when you have COVID-19 Act, which is actually currently in force, is there any, what do you call, any need that we need to amend, and any, what do you call, measures that we need to address in order to make it more effective? And what is your views on this? Maybe we'll start with Dato Jeffry.
Yeah, Dato, I think for in the perspective of the bank, I think first and foremost, I think the core priority is how can we assist the customers down there, right? So whatever I think covered under that COVID Act, no, I should, to us it goes to both parties, be it the consumer or be it on the so in the perspective of the banks, I guess it is something that it, as long as it helps, it helps the consumer to really withstand during this hard time. For us in the banking, I guess we basically got to support the agenda of the government, to support, like in terms of moratorium, in terms of giving that relief what do you call it, fund to the SMEs, to support the SMEs, to support the local micro SMEs. So we definitely have to support all this, right? So whatever is covered under the Act, as I said, no doubt, like if I mentioned earlier about the specific on HP Act, right? That the bank you shouldn't say repossess car during this COVID. To us, is as far as it is something that we able to assist the consumer. I think it will be fine, because at the end of the day, what's important is, I think we are doing our social obligation also, in a sense, right, to support the consumer. On our part, I think we continuously look at the targeted repayment assistance. I think we're talking about the targeted B40 and T40 that we are M40 that we are targeting now, and how can we really give that sort of financial relief to them. At the end of the day, what is important is, I guess we are in support of the agenda of the country. Yep.
Okay, thank you,
Yep.
Dato. Thank you.
Yep.
Dato Soam, you have any last views?
I think this is part of just one part of the webinar that we have. That's why we have a series of, but today we have talked a lot about the construction side, professional services. But I think the main one that I think a lot of the listeners listening in is actually regarding addressing issue between themselves, the developers and the purchaser. I think that has a different perspective. And I think that the AG chambers, during the time that, when we have engagement with the Ministry of Housing, they say that the most difficult part to address is actually the one related to property development. Okay, but they forgot about the construction contract as well, which is part of the whole chain. So we keep telling them that you need to align this date with this date, align this with that, but they fail to do it. So on that note, I want to just advise that developers who have queries as to what needs to be done, because I see a lot of questions related to what they need to do, CMCO, MCO, and all this. So maybe they still don't have a good understanding of what this COVID-19 bill is. We have a guideline issued jointly between the Ministry of Housing and ourselves, which is posted on our website. So you can go in there to look at the various scenario that you have with regards to the freezing of the time between the commencement of the MCO 18th of March to 31st of August, and then the ability of developers to apply for additional time if you cannot comply to the completion date up to 31st of December. Same time as for purchaser, if you cannot actually comply with the obligation in the contract that you have, you can actually apply to Minister of Housing. I mentioned here, Minister of Housing, he's the minister in charge of that act in particular, to also extend whatever there is to 31st of December, so which is only 3 weeks away. So for those who didn't apply, I think this is a time that you need to apply. And the other question I think a lot of them have is whether they have now got a letter of acknowledgement and approval from Ministry of Housing signed by the DG. So I think some of them have this burning question to ask whether it's valid or not. I think maybe before Dato Nitin depart, so Dato Nitin, maybe it's a question I pose to you here as because there have been argument to say that if a developer is supposed, because the time from 18th of March to 31st of August is frozen, okay, which is 5.5 months. So if my completion date falls say in December, now I will get another 5.5 months added to my completion date. Okay, so what some of the developers want to know is if they have now got an acknowledgement from the ministry, okay, but it's not signed by the minister, it's signed by one of the officers, is it valid or not? And some developers have gone to the extreme to say that under the current act, I don't need to apply at all if I want the date up to 31st of August, which to me, I interpret is not wrong. But what the ministry wanted to do is to administratively cover everyone so that in case of anything that crops up later, they are in the know. Okay, so maybe you want to address that, whether they need to apply for that freezing of that period up to 31st of August, and then if they want to go to 31st of December, must they apply and must they get approval letter signed by the minister, or is it valid if it's signed by the officer, because they are worried about the unmingly case? Okay, Dato Nitin, maybe you want to...
That's a tough question you posed, but here's the reality. Right now, we're in the middle of a crisis, and everybody remembers this crisis, and it's uppermost in their minds, and we talk about common sense, and we talk about this, and we talk about that. By the time any litigation involved in this case gets to the federal court, it'll be 5 or 6 years down the road.
Yes.
By that time, everybody has forgotten about the crisis. Everybody has forgotten about common sense. Everybody is looking at the law and the contract, and they will look strictly at the law. That's lesson number one. Lesson number two, as I think I've said before, every single judge buys a house one day from a housing developer. So every single judge has a child who buys a house from a housing developer, and a brother or a sister. So they are looking at it from the perspective of a house buyer. So if you got to go the extra mile and make sure that everything is, you've crossed every T and dotted every I strictly in accordance with the law. Mere administrative directions, sorry, if you look at Ang Ming Lee, it's so clear they don't care about administrative directions. So you got to bring yourself within the act. You get an automatic extension of time. If you want something more, the minister has to do it, not some administrative officer. That is the reality of where we are today, I'm afraid. That is the housing. I mean, you can see to give the example everybody talked about. The housing developers' defects liability period has been extended because every single civil servant is also a house buyer. But the defects liability period of your contractor has not been extended.
Yep.
Similarly. So I'm afraid that you are always the person in the middle who is going to have to pick up a lot of these issues. And the only thing I can do is to say, make sure that all your documentation is properly done and you have complied strictly with everything in the law. Because the courts are not going to be that sympathetic to you as they are to the house buyers.
Yeah, because some of the question here is some of the developers are arguing to say that based on clause 35(2), they actually don't have to apply at all. If you look at clause 35(2), because it says the developer may apply to the minister for an extension of the period referred to in subsection 1. That is for if you want beyond 31st of August up to 31st December. Okay,
that's correct.
Meaning that if it's up to only 31st of August, that means you want a period from 18th of August to 31st of August, 18th of March to 31st August, you don't have to apply.
That's correct. That is what the Act says. But you want anything more, and you can't get a letter from the civil servant. Number two, if the civil servant writes you a letter to say, oh, I think section 35(1) means this, the court will pay no regard to it at all. Because that's that is the view of a civil servant as to what it means. And I did a case many, many years ago called Chia Tiam Sui. I don't know, those old timers will remember he used to be a deputy minister against DNC Bank, where the Justice Zakaria Yatim said, I'm not interested in what civil servants tell me the law means. I am the judge. I tell you what the law means.
Okay.
Okay, thank you so much. I think as the time do not permit, probably we will have to adjourn this forum itself. And just to remind the participants, we still have 2 more webinar sessions. And I think most of the question that was posed on the Q&A, they actually refers to mostly construction. And tomorrow, I think we are going to, in the next session, we will be getting Mr. Rajendra Navaratnam, Mr. Oliver Wee, and also Dato Soam and Dato Jeffry to be together with us again in the next session on construction and building contracts. So with that, I think I would like to take this opportunity on behalf of REHDA. Thank you, Dato Nitin, Dato Soam, Dato Ezumi, and Dato Jeffry for being with us today. Thank you very much to all the participants for listening in. Thank you.
Thank you to all.
Thank you to all.
Thank you.
Thank you.